Hello and welcome back to the channel. I'm Miriam, part of the team here at Canada. Did you know that even a single past criminal conviction can make you inadmissible to Canada? Many people are surprised to learn that offenses such as DUIs, theft, and assault, even from many years ago, can prevent them from entering the country. The good news, however, is that Canada does offer solutions for individuals who find themselves in this situation. One of the most important options available to these individuals is called criminal rehabilitation. In this video, I'll be explaining what criminal rehabilitation is, who qualifies, how the process works, and answer some questions that people have in terms of overcoming criminal inadmissibility. What is criminal rehabilitation? Criminal rehabilitation is an official process created by the Canadian government that allows foreign nationals to overcome criminal inadmissibility. If your application for criminal rehabilitation is approved, then Canadian immigration authorities recognize that you have been rehabilitated and that your past offense should no longer prevent you from entering Canada. In simple terms, it means that your criminal history will no longer be a barrier for future travel to Canada. This process recognizes that people can learn from their past mistakes, change their behavior, and move forward as law-abiding citizens. Now, what is deemed rehabilitation? In some cases, you may or may not need to apply for criminal rehabilitation. Deemed rehabilitation can happen automatically after enough time has passed since your offense. For example, if you have one non-serious offense, you may be deemed rehabilitated after 10 years have passed since you completed your sentence. This includes probation, paying fines, or any other penalties ordered by the court. However, it is very important to keep in mind that deemed rehabilitation only applies to certain minor offenses. Obviously, more serious offenses, such as crimes that carry longer prison sentences in Canada, do not qualify for deemed rehabilitation. It is also important to remember that even if you believe that you are deemed rehabilitated, it is ultimately up to the discretion of the Border Security Officer to make the final decision when you attempt to enter Canada. Who is eligible for criminal rehabilitation? If you do not qualify for deemed rehabilitation, you may still apply for criminal rehabilitation. Generally, you can apply for criminal rehabilitation 5 years after completing your full sentence for the offense. This means that the 5-year waiting period begins only after all conditions of the sentence have been completed. This includes probation, fines, or license suspensions. For example, if your probation ended in February of 2020, you may become eligible to apply for criminal rehabilitation in February of 2025. In order to be approved, applicants must demonstrate that they have changed their behavior and they are unlikely to commit another offense moving forward. Now let's discuss processing times. Processing times for criminal rehabilitation are typically between 12 and 18 months. However, times can vary depending on the case. There are also government processing fees. This depends on whether or not the offense is considered serious criminality or non-serious criminality under Canadian law. Now let's fire through some common questions people ask about criminal rehabilitation. Can I travel to Canada while my criminal rehabilitation application is being processed? Yes, in many cases you can. However, in order to do so, you must apply for a temporary resident permit, also known as a TRP, if you need to travel to Canada before your rehabilitation is approved. Is criminal rehabilitation permanent? Yes. Once approved, criminal rehabilitation is considered a permanent solution for that offense. It will remain this way unless you receive a new conviction in the future. What if my criminal rehabilitation application is refused? If your criminal rehabilitation application is refused, you do not need to worry too much, as you may be able to apply again. But it is important to understand the nature of why your application was refused in the first place and then strengthen your application before reapplying. So no, a past conviction does not mean that you are banned from Canada forever. Processes like deemed rehabilitation and criminal rehabilitation, as we just discussed, are in place because Canada recognizes that people can move forward from past mistakes. Having said that, the process can be very complicated, and even small mistakes or missing documents in your application can lead to refusals or delays. If you know or you think that you may be inadmissible to Canada due to a past offense on your record, our team at Canada can assess your situation, give you top-tier legal advice, and guide you through the process from start to finish. You can reach out to us anytime by emailing us at help@canadeem.com or by giving us a call at 1-8 844-774-0700. As always, thank you so much for watching, and if you found this video helpful, please do not forget to give it a thumbs up, share it to a friend, and subscribe to our channel so that you don't miss any helpful immigration videos such as this one. If you have any questions about criminal rehabilitation or deemed rehabilitation, please drop them in the comments below. And if you have any requests for future video topics, please also let me know in the comments below. I will do my best to answer every comment, and I'll see you in my next video. Bye!